Hi, everyone. My name is Mona. I'm an intern for the Legal Education and Resource Network at ASUCI, and I'm also a staffer for the Legislative Affairs Commission under the Office of External Vice President. Thank you so much for joining us today. We're going to be going over housing rights, and we have Monica Graham here with us, who's an attorney, as well as Brian Beard, who works at the Veterans Legal Institute. And we're going to go over some questions regarding housing and tenant rights in order to give you all an introduction of some things to consider as you move into housing in the future. So first, Monica, do you want to introduce yourself first?
Hi, everyone. My name is Monica Graham. I'm an attorney in Southern California. I have over 30 years of experience in real estate. I've been in litigation for the last 10 years. Prior to becoming licensed, I was a practicing law student. And before that, I also worked under a couple other attorneys, very, very active in real estate law, wrongful foreclosures, and landlord tenant cases.
Thank you. And Brian?
Hi, everyone. My name is Brian Beard. I'm a staff attorney over at Veterans Legal Institute, which is sort of a nonprofit law firm for poor and homeless veterans. I am a UCI law school grad, so I just graduated last year from UCI Law School, and I've been working in housing during the whole coronavirus pandemic. And I have experience in a few different areas. Like when I was a law student, I clerked at the district attorney's office. But this year I've been mostly focusing on housing, and I'm excited to talk to you guys about housing law.
Thank you. So we'll just get started. So our first question is, which aspects of the contract, of the housing contract, are the most important to go over? And what are some things to look out for in order to ensure that it's a fair contract?
I'll go first and then I'll let Brian speak. The clients that I deal with, the most important part of the contract is the expiration date of the lease and the type of lease that it is. So you need to know if you're entering into a month-to-month or if you're entering into a lease. And if you're entering into a lease, when does the lease expire? When you're a student, you know that there are several things that you need to keep in mind. When you're going to graduate, who you're contemplating moving in with. If you're able to live by yourself, that's fine. If you have a roommate, you need to consider what their objectives are, what obstacles that they might face. You also need to keep in mind, if you're going to go into a lease long-term, what if something doesn't go your way? Maybe you would have been better off with a shorter term lease. So the most important things really depend on your personal situation, your goals, your affordability, family, if you have family nearby, if you don't have family nearby, all of those things come into play. And then the last thing I'll mention before I let Brian chime in is most leases are standard, rental agreements are standard. They don't allow assignments or subletting. But if that's something that you might be considering, you just want to look out for that too. If the landlord would let you, if you need to move out, if you need to, maybe you're changing schools or transferring or something like that, is it possible to let someone step into your place if you cannot break the lease? Brian.
Yeah, and I would agree with that too. I do agree that, obviously the kind of lease you have, the month-to-month or year-long, is super important. I see a lot of people get confused about which one they're signing to, and it causes problems down the road because there's a whole variety of different protections depending on what kind of lease you have. And I was gonna, you added it there at the end, but I was gonna mention the sub-leasee and assignment thing as well, because I know as a college student in the not too distant past, if summer breaks off, maybe going home to visit your parents, or just roommates come and go, maybe they join a frat and decide they don't want to live there anymore or something like that. Assignments, subleasing, it's so common. It's basically, it's so ubiquitous. It's like everywhere you go. I had a group of friends who 4 of them were living in 3 different apartments, and none of them had a lease or written lease. And they were all just basically, I have an oral agreement with the person who's on the lease. And so it can be I know it's tempting, of course. I think it's a dangerous situation to get yourself into where you don't have a written lease. It can be tempting, like inconvenient and quick, because you don't want to have to go through the hassle of applying for a lease and qualifying for it and stuff like that. But I would look at the subleasee as a college student. I think it's super important. And as Monica mentioned, it in almost every lease I've ever seen where it was like a standard rental agreement, it's prohibited without approval. But sometimes you'll get private landlords who don't own a whole ton of properties, and their rental agreements are a little bit more informal. So that's definitely something to keep an eye out for. And I would just add that I know some leases will have differing amounts of notice in terms of how much notice you have to give if you want to terminate the lease. So that's just something you want to look out for too, as well, whether, because there's certain laws in place that are minimums, but sometimes landlords will add clauses about like how much notice you have to give and things like that.
Great, thank you so much. And our next question is, what are some questions that we should ask our landlords going into a contract?
Brian, you go first.
Okay, I have to think about this one for a little. So questions I would ask my landlords, of course, I would ask how they want the rent to be paid. Especially with the corporations and stuff, a lot of the times it's easy to pay online, and that's wonderful because there's a clear record and it's usually pretty easy to just link your bank account or do something like that, or set up auto pay or whatever you want to do. But definitely on some older properties, you want to be 100% clear about when the rent is due, if there's a grace period for late rent, and the form that they want their rent in. So I mean, I see problems arise in this realm sometime before, because there's just no conversation about it, and people just assume, oh, I'll just put it in my landlord's mailbox or something like that. So I would definitely talk to them about how rent is to be paid if you're living, especially like with not a corporation, like a more private landlord who maybe doesn't know the sophisticated processes to have like an online rental payment system.
That's great. I'll add on to that what Brian said about the payment. How does the landlord want to be paid? Two things are important. Where does the landlord want to be paid? I have clients now, they don't know where the landlord lives. They intentionally concealed their whereabouts on the lease. So that's a problem if you have a bad landlord and you need to sue that landlord. We don't know where they're going to be served. So that's one question. Where do you live? Where am I mailing the rent to? And another thing that's important is that the landlord cannot demand cash. So it has to be also another form of payment. So the question I ask, if the landlord says you need to pay me in cash, what is your other source of payment that you accept? I really encourage online bill pay. I've never had a check get lost. It's for free. I do not like money orders. I do not like cashier's checks. There's much too much work involved in getting those reissued when they're lost or misplaced. And so those are the two most important things with landlords. And if you don't need to get real personal, but you might want to know what their future plans are for the property. If you're in a month to month and you're not sure how long you're going to live there, or something like that. Right now, what we're going through with COVID is landlords are they're lying. Okay, they're lying and saying that their family members are going to move into the house because that may be the only way for them to get the tenants out. So just a little bit of questioning, but other than that, there's not a whole lot to ask the landlords.
Okay, great, thank you so much. And our next question is, well, there's one question in the chat if you want to answer that now. It's, after a lease is over, does the property owner generally let you begin paying month to month instead of a lease agreement?
Good question. When your lease is expiring, 30 days prior to that expiration date, the landlord should send a courtesy notice letting you know that you're entitled to a pre-move out inspection within 2 weeks of vacating the property. At that time, normally there's some kind of a discussion or an offer to be made whether or not the lease will be extended. Now, I have a lot of clients and they've been in the house for years and they just knew year after year after year, the landlord was going to let them stay. So it's not something that you find out at the last minute. It's something that there's normally a conversation, some kind of correspondence is going back and forth leading up to the expiration. Or if you want to extend the lease, you need to just straight out ask. But don't assume yes, don't assume no. But keep this in mind. I have to explain this repeatedly. The landlord does not have to extend the lease. They don't have to. So when you have an expiration date on your lease, expect to move out. And if you want to stay, you need to communicate your desire to stay. And that way the landlord knows your intentions and they're not out making commitments to other prospective tenants.
Okay,
You go.
thank you. Oh, is it not letting you?
Thanks. I
Oh,
muted
sorry.
because
Oh.
my cat was meowing a little earlier, and I was trying to mute, and then it would not let me unmute. So I apologize. But yeah, no, I mean, I agree with everything Monica's saying. You know, I've had, again, with corporations, it's a little bit more straightforward, but with private landlords, especially, like private individuals who maybe only own one property, an older property or something, it can be pretty confusing because sometimes they won't even write up a new lease. They'll just give you a piece of paper and say sign this. Or I've had tenants come to me who the landlord doesn't even ask them to sign. They just send them an email saying, oh, the lease is going to continue. So it can be a confusing thing. But I totally agree with Monica that like you shouldn't just assume. You need there to be clarity, a conversation at least, and then signing a new rental agreement. Whether it's transitioning to a year long or just to month, if it's staying year long or transitioning to month. And I would say I mean, at least with my clients, I serve only a very like specific subsection of the population though, like poor tenants and things like that. But I would say it's pretty common to transition to month after a year long, at least for my clients. I don't know about you, about your clients, Monica.
Thanks.
Thank you. So our next question is, how has COVID-19 changed protections for tenants?
So I can talk about this one a little bit first, Monica, if you want. I know you've been practicing this area a lot too, but pretty much all of my UD work so far has been with the coronavirus laws in place. And the first thing I want to say, because I feel like this is a conversation I have to have with all of my clients, is you probably heard there's a moratorium on evictions right now, that people can't get evicted because of coronavirus. And it's a really misleading statement because while there are definitely protections in place that prevent people from getting evicted due to coronavirus, people are still getting evicted because they can't pay their rent due to coronavirus all over the place. Like evictions are still happening and you can still get evicted for a whole number of other reasons as well. And sometimes it's a landlord, saying that it's a different reason that's not coronavirus related and they're evicting the tenant that way. Or sometimes, sometimes they're basically getting around the coronavirus restrictions by lying, by saying that the client hasn't complied with the law. So I thought I would just say a little bit before I pass it over to you, Monica, about basically if you have coronavirus debt, like say you have an income that's affected by coronavirus, basically what you do is, I think it's always good to like informally talk to the landlord and let them know that beforehand, but they have to post a 15-day notice on your door that says, with these declarations attached. And if you submit the declaration to the landlord within 15 days, they can't evict you, or they're not supposed to be able to evict you. Now, I've had landlords claiming that the declarations weren't submitted or they wasn't signed or something like that. But generally speaking right now, if you can't pay your rent due to coronavirus and you file these declarations every month or however often the landlord is posting them, they can't bring an action against you. And then if an action is brought to right now, you can file with your answer, which is basically a fancy way of saying when someone's suing you and they filed a complaint against you and served you with that, you basically file your answer in response, and you can file a COVID declaration with that as well. And this triggers a special hearing that has been going on right now. I've just been calling it a COVID declaration hearing, and that's what most people have been calling it as well. But basically, it's an informal hearing, and the judge determines whether the tenant should have been able to submit the declaration properly and should be entitled to the protections during the pandemic period. And it's kind of informal, you know, there's not a lot of rules on it right now because it's kind of new, and no one, I would say, having gone to a few of them now, no one really knows exactly what they're doing at these things, but usually I found, at least with my judges, actually it varies from judge to judge. Some judges don't even do these COVID hearings. You have to really call them and get them to do them. Others will automatically schedule them, but sometimes they get dismissed and sometimes they don't. So I know it's a lot of information, but basically to sum up, I just wanted to, because there's a lot of misinformation out there, I don't want people to think that they can't get evicted right now due to coronavirus, because people are still getting evicted, and there's very specific requirements in order to get these coronavirus protections that you have to comply with.
Yeah, totally correct. The biggest impact from COVID-19 is the ability to avoid eviction due to non-payment of rent, so long as they complete that declaration. And for high income tenants, tenants that earn over 100,000 a year, the landlord is able to request proof of the income, but people under 100,000, landlords cannot even request proof. So that's the biggest impact. And Brian's right, tenants can still be evicted for breaching the terms of the lease if they're wreaking havoc, if they're a nuisance, if they're causing trouble, doing other things that they shouldn't do in contradiction to the terms of the lease. Those evictions are still happening. So.
Thank you so much. And our next question is, how do we cancel our leases?
In writing. In writing, under the terms of the lease, you cannot cancel a lease early. You have to negotiate an early termination. But when canceling a month-to-month rental agreement, in California, you only need to provide a 30-day notice unless the agreement says otherwise. And you send the letter in the mail to the landlord, and you tell them when you plan to move out. And some people get confused by this. You don't have to serve the notice on the first of the month. It's effective 30 days from when you serve it. If you regularly communicate with the landlord by email, you can email it. If you regularly communicate with the landlord by text, you can text it. But keep in mind that when you tell the landlord that you're going to move out, don't change your mind. Because if you try to change your mind, and if that landlord has already acquired a replacement tenant, you can now be evicted because you gave notice and then you changed your mind. Now, don't get me wrong, you can get the landlord to agree to let you stay, but you do run the risk of being evicted. Brian, you can add.
Yeah, of course. I mean, you really pretty much covered it. You nailed it there. I don't know how much more there is to add. I do see, I do agree that like changing your mind is a dangerous prospect. There should definitely be communication there if you do decide to do that. I thought I would mention too, at least for a month to month, the landlord, well, it depends on for what reason they're evicting you, but like a landlord can terminate the lease with a 60-day notice on a month-to-month tenancy for what we would call a no-fault eviction, or I believe, yeah, so no-fault eviction. So there's a number of reasons a landlord can just terminate the lease, where it's not you violating the terms of the lease. Basically, they've decided that, oh, they want to move in, or they're taking the property off the market or something like that. But I just thought I would highlight that it's not exactly symmetrical. The tenant has to give 30-day notice, but depending on the situation, the landlord has to give 60-day notice.
Yes.
Thank you. And our next question is, how do evictions work? So if you can just give a general overview.
Sure. Did you want me to start, Monica, or do you
No,
want me to?
you can go.
So, well, I'm a little bit newer to the housing arena, but basically the overview of the eviction process that, the parts of it I've seen at least is, so in California, so basically it all starts with a landlord claiming that there's some breach of the lease usually, if it's an at-fault eviction. So let's say the simplest one is the tenant is unable to pay rent. Now, essentially, the first thing the landlord has to do in this case is they post a 3-day notice that says pay rent. I'm sorry, it's pay rent or quit. So it's like cure or quit. You have 3 days to comply paying the rent, or like they have to give you that 3-day warning. And there's a lot of technical requirements about the 3-day notice. And there's different amounts of notices for different kinds of breaches. But basically, at that point, if you don't pay the rent, the landlord can go to court and file a complaint against you, an unlawful detainer, which is the term we've been using, but it's commonly known as an eviction. And at this point, the landlord files a complaint with the court. Then they have the process where they have to serve you with it. Now, usually they'll use a process server, someone who's hired to officially go serve the defendant with the notice of the eviction proceedings. But sometimes if the process server is unable to serve them, and I don't know how often you deal with this, Monica, but at least it's happened at least in a few of my cases, it seems pretty common. If they're unable to serve you, they'll send it by mail. And this process can, I think for mail, they send it and then it's effective 10 days after, and then you have 5 days to respond. So it's like and this is court days, so like business days we're talking about. So it's like a 3-week period, in which case at the end of that you will be served essentially, and you have to file an answer. After you've filed an answer, either party, but usually the plaintiff, will file a request to set the court date. And I'm trying to think if I probably won't go into like all the other little steps you could do, because there's things like demurs and motion to quash, but I don't think it's necessary to go into detail on these as well. But essentially, the trial is set usually about 3 weeks after that, or no earlier than 3 weeks after that. And then there will be a trial, and if it finds in the plaintiff's favor, then they will get a writ of possession, which is essentially posted to the tenant's door, and a sheriff will come and escort you off the premises. And that's sort of like the process from start to finish. Monica, if you want to like add anything I left out, feel free.
Yeah, not much to add. You covered it. This is kind of a technical area. The most important thing to know for the students is that if you ever receive an unlawful detainer, you need to stop what you're doing and get a response filed. 5 days comes really quick, and you need to file that response, because most plaintiffs are just waiting in the starting blocks to file that default judgment. So it's a game of speed. You've got to get that done. So that's the most important thing to know about evictions. Don't sleep on them.
Yeah, and like unlawful detainers, everything moves so fast compared to like pretty much all other litigation. Everything's a shortened time frame. Discovery is shortened. It's just it is crazy how fast it'll all go if you let it.
Oh, I'll add one thing. On service, Brian mentioned that sometimes that the unlawful detainer can be mailed. That is called post and mail, and they actually need a court order to do that. So if you ever get in a situation where you are receiving an unlawful detainer, or maybe you know someone that's receiving it, they need to be served, personally served. And it's very suspicious if you come home and papers are all over your front lawn or under the mat or sitting on the welcome mat or whatever. Luckily, I've had people that have had ring.com and they've captured defective service on camera. But the process server needs to personally serve it to someone over 18 that's there in the home, or they need to serve it on you, or if they can't catch up with you, then the plaintiff has to go to court and get an order after 3 attempts.
Mhm.
So just be suspicious if you see papers lying around. That's bad service.
Yeah.
That needs to be rejected with motion to quash.
Mhm.
Yeah.
Great, thank you so much. And our next question is, do we have any protections when roommates do not pay their share of rent or utilities?
Not much. I have seen the bad side of this many times. So the best thing that roommates can do, and this may cover a future question in as well, the best thing roommates can do is have their own agreement. I don't even care if you put it on a napkin. You need to have your own agreement, what each roommate is promising to do. If you're splitting the utilities, if you're sharing cleaning duties, if you're sharing chores, whatever it is, you need to put it in writing. You also need to put in writing when you're both deciding to move out, that it's all or nothing. But the protections that roommates have if they don't pay their share of rent or utilities is to take the other one to court, most likely small claims. But that's how it needs to be handled. The more things you have in writing, the better off you will be.
Yeah, so I would just add, of course, everything Monica says is correct. And so like, to me, it depends too if you're both on the lease. If you're both on the lease, there's not much you can do. And if you're not on the lease and they're on the lease, there's pretty much nothing you can do. Now, if they're like a subleasee who's not on the lease, but they're kind of just living there, you have a little bit more leeway. Now, I've never dealt with this situation personally, but my understanding is that you could, I think, bring eviction proceedings against a subtenant if I'm not mistaken. Do you know, is that correct, Monica?
The subtenant is in privity with the roommate. So the roommate can sue the subtenant, but the landlord is not in privy with the.
Yes. So that would just depend. You have some more options if they're like a subtenant with you, but if it's just a roommate and you're both on the lease to the landlord, it's pretty much you have to sue them for their portion of the rent, and that can be hard to do. And so it's not the best solution, but it's what we got.
And I want to make this clear, and it goes to the heart of the question. Do you have any protections when roommates don't pay? Not only do you not have protections, but you have to pay your roommate's share. Okay. So if you want to keep the utilities on, you have to pay him. If you don't want to be evicted and roommate is not covering his or her fair share of the rent, you have to cover it. So no protections when it comes to a roommate that is slacking. Okay.
Yeah.
Thank you. Yeah, that's really important. And our next question is, are landlords responsible for repairs? Does it vary? And if so, where in a contract would that be addressed?
So generally speaking, landlords are responsible for repairing the property. I was just going to add my 2 cents in the sense that, like, again, this is something, because I work with like poorer or more homeless veterans, this is something that I think they deal with more than the average tenant. But if something's defective to the point where it's affecting your habitability, you're allowed to, say, potentially make the repair yourself and deduct the portion you repaired from your rent, or reduce rent based on habitability, or in extreme cases, possibly not even pay rent. But it really has to get to the heart of habitability. And even in these situations, you really need to let the landlord know and give them an opportunity to repair. And your repairs have to be like reasonable. They can't be excessive or upgrading, the cabinets to something far more gaudy or something like that. Right. But yeah, so generally speaking, yeah, the landlord does have a duty to repair. And Monica, I don't know if you wanted to add to that.
The only thing that I will add, because everything Brian said is correct, what's a little bit different is if the tenant is responsible for the damage. So The benefits of being a tenant is you get to call the landlord when you need the toilet fixed and things like that that go wrong that aren't the tenant's fault. But when the tenant is at fault, don't call the landlord, just handle it yourself.
Mhm.
That's what I'll tell you. Yeah.
Yeah, definitely true.
Yeah,
I've
thank you.
had people move out and they don't want to be charged for the broken window. And I get it. Maybe the kid down the street threw a baseball and he broke the window, but because that damage happened while you were during your tenancy and the landlord wasn't at fault, then that's something that the landlord is not going to pay for. But
Mhm.
other than that, it's pretty clear cut how Brian and I explained.
Yeah.
Thank you. And what protections are there for tenants against unfair rent increases? And what is the maximum amount a landlord can increase rent?
Are you dealing with any rent increases with the VA, with the vets?
So I have had to look into this issue a little bit, and it looks to me like what is it? So AB 1482 provides a pretty clear rent increase limit. So this is a bill that passed a couple years back and went into effect last year, and it provides some rental protections for tenants statewide. It's a pretty great bill, but it doesn't apply to everyone, and there's some important exceptions. But generally speaking, if you fall under this bill, there's sort of a complicated measure of like how much they're allowed to increase the rent, but basically they're not allowed to increase it more than 10%. And sometimes they can't even increase it less than that, but definitely not more than a 10% rent increase. But the thing is, not everyone qualifies for these protections. So there's a couple of different exceptions that make it so that this bill won't apply to you. And so you kind of have to look that up ahead of time. The biggest one is if the building you live in is newer than 15 years old. So like it's younger than that, this bill does not apply. And there's a few other exceptions for like condos and things like that as well. But generally speaking, that's the statewide rent protection. Now, counties and cities all have their own different rental protection ordinances as well. So this is one where it's really hard to speak broadly because even cities and definitely counties just operate very differently from even within California.
Yeah. Yeah, that's all correct. I basically say that the rent increases ranges from 5 to 10%. The best advice if that's something that you're concerned about before you rent, just Google the city that you're looking into and just Google their housing agency, and you can find the details on a website. And then the housing agencies are great. You can call them if you have any questions.
Mm-hmm.
Yeah, but how you would deal with it if someone improperly raised your rent, I start everything out with a demand letter. I give that landlord an opportunity to resolve the situation outside of court. And then if they don't, then your remedy is in court.
Mm-hmm.
Okay, thank you.
Mm-hmm.
And what should students know about net income determinants or minimums? And are there any laws that protect students in this regard?
I will just say that you need to find out what the landlord's qualifications are before you apply for your rental. You don't need another inquiry on your credit report, and you don't need to pay an expensive credit report fee because you're curious. You need to know if you qualify. And then if the landlord has net income determinants, that just means that the landlord is looking for a certain number that your income needs to exceed as far as the rent. So if your rent is 500, they might say you need to make 3 times the amount of the rent. So that's how that works. So it's not confusing. You just need to know what the requirements are. And you need to know also to make sure that if you qualify and the rental is not given to you, well, why not?
Mhm.
So there are some crazy things going on right now since we're in a housing crisis. I think some landlords and property managers are actually now in the business of collecting credit report fees because so many people are applying for one unit. You can only give it to one person. So common sense dictates, if you already have that ideal candidate, why are they still collecting application fees and credit report fees? So I would stay away from those. But other than that, that's basically what you need to look for as far as these income determinants.
Yeah, and I mean, I think that's great advice. There's not really as much I can contribute here because my clients, because they tend to be indigent, don't. I haven't had to deal with this particular issue myself in my practice.
Okay, thank you. And our next question is, what is a guarantor and what are they responsible for? Or what are they legally obligated to do? And how does this present a challenge to some tenants, especially for students who are younger?
So a guarantor is basically like a third party who's agreed that they'll pay the costs, usually the rent, but sometimes other costs as well, if the landlord's unable to collect it from you. So it's a really powerful tool for someone who maybe doesn't have strong credit history or doesn't meet the minimum income requirements, so they can, potentially get an apartment or someplace like that while they're in a sort of limbo. Like I'll say, for me personally, I used a guarantor right after I got out of law school, but before I took the bar exam and passed and everything like that. I couldn't start practicing law yet. I knew my income would be a certain amount once I passed, but before then I needed somewhere to live. So my parents were kind enough to be my guarantor, and that allowed me to qualify for an apartment that, I knew I would be able to afford in a few months' time, but at the time I would never have been approved for. So, I mean, for that, in that sense, I think a guarantor can be a powerful tool that can help you. But a guarantor is, they can be sued at the end of at the lease if, say, you default on the rent payment. The landlord can come after them. And I mean, that's the whole purpose of a guarantor, is essentially to provide them with a fallback plan if they're unable to collect the rent from you.
Thank you. And just adding on to that, do you think there might be some situations if a student doesn't have like a family member that they can ask to be a guarantor, where that would sort of pose an obstacle for them to gain access to housing?
Yeah, I mean, I definitely could see how that'd be an obstacle, because without credit history, I mean, this is sort of a catch-22 that you often see with young consumers, is that they don't have credit history, so they won't be approved, for whether it's an apartment or a credit card or whatever, and they can't build that credit history until they get approved for one of those. So it can definitely be an obstacle, because for a lot of people who have those people in their lives who can be guarantors, that's a way they can start that credit history and then build on that, and then be in a position where they themselves can build credit. But for other people who don't have those people who can help them out in that way, it's definitely a huge obstacle.
Thank you. Okay, so our next question is, can a student be denied housing if they have a bad credit history?
Sure. Yeah, a landlord is entitled to decide who he or she wants to rent their property. And a landlord is definitely going to favor a prospective tenant with good credit over one that has bad credit. So I don't think credit has ever been more important than it is right now. If you're on social media, you're on TikTok and everything, you've got all the credit gurus on there. Listen to what they're saying. Don't get scammed, just listen. And credit is extremely, extremely important. So yes, they can certainly deny someone with bad credit. It's not discrimination, it's a risk factor. And basically, a tenant with bad credit is more risk for a landlord, because then that tenant doesn't have much to lose if they default in the rent and an eviction is being threatened. Because what's a judgment? I have all this bad credit, I'm not going to do anything anyways. So you students need to work really hard to keep your good credit. Don't do favors for people, and always keep that in mind, that bad credit sticks around for 7 long years if you're not able to delete it. So it's not worth doing any favors for, because you don't know what you're going to need to do 2, 3, or 4 years from now, where you're going to need your credit.
Yeah, and it's definitely avoidable too, especially obviously the worst thing really you can have on your record is an eviction judgment, because that, you know, that's basically the number one thing landlords look out for to prevent someone from you know, being approved for an apartment. And I always am sad to see these, because they're really very avoidable in the sense that I'll just walk you through like a little bit of the process. So basically, eventually at the end of the eviction proceedings, at some point, a sheriff is going to come and remove you from the premises. So you're not going to be able to stay there indefinitely. And if before the judgment is entered, you leave the premises, the court can't, and it basically, it turns into a civil action instead of an unlawful detainer action, and an eviction judgment can't be entered against you. So it's so avoidable. You might have to, you know, move out a week or 2 earlier, but ultimately can make the difference between having an eviction on your record or not. And that is such a huge thing when you're applying for apartments.
Yeah, it's a death blow right now. If, you know, California doesn't have enough housing, so if you have bad credit, you're going to be the last pick, because if someone has good credit and you're competing with them, they're going to go with the person with the good credit.
Yeah, thank you. And our last question is, how do students request an explanation for why they haven't received their security deposit back?
Well, the security deposit needs to be accounted for and returned, if it is refunded, within 21 days from the date that they vacated the property. And I am extremely busy with this civil code. It's Civil Code 1950.5. And the most important thing is that you request a pre-move out inspection to take place within the last 2 weeks of your tenancy. You and the landlord need to agree on a specific date and time. Do not blow it off. You need to show up. You need to walk through the property with the landlord or the property manager, and they need to point out everything that needs to be fixed, repaired, or corrected in order for you to get your security deposit back. So if you go through all those things, and I get a lot of people saying, oh, they said everything was fine, they said the house looked good, da 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 da, and then next thing you know, the landlord or the property manager is deducting everything that they could possibly think of, that is wrong. I get remedy for people in those situations. And so you have to respond within 2 weeks of getting that. Don't sit on it. You have to respond right away. And basically, I don't want to overcomplicate it, but the landlord or the property manager cannot deduct what was not discussed or left in writing the day of the inspection, okay? So if you talked about a broken window, if you talked about fixing a doorknob, patching holes in the wall, you as the tenant, you are discussing this now, so you have the option to do it yourself or let them deduct it from your security deposit. What is not supposed to happen is a big surprise. You're not supposed to get deductions that go to normal wear and tear, or things that the landlord is fabricating or just don't exist. And it's common because I firmly believe that landlords and property managers, they take advantage of this statute. They take advantage of people not standing up for themselves. And I believe it is a side hustle. I have seen situations where a certain property is just a revolving door. They let family move in, the family's not happy there, whether it's rodents or cockroaches or whatever, they move out, the landlord keeps the security deposit, they move someone else in, and they do it again and again and again. for a property that's in bad condition and is infested, this is a really good way to get money and not collect rent. So the best thing to do is communicate, respond, and contact an attorney if you're confused in any way. Do not let them keep your money, okay?
Yeah, and Monica really laid that out recently. I had a client recently who had a similar issue. And essentially, this was an interesting situation because the landlord also owned a construction slash what's like a refurbishing kind of company. And he just ran all the repairs through his own company and charged outrageous amounts for things he didn't even point out in the walkthrough. And it's just, I mean, it doesn't even surprise me anymore to see like the things the landlords will lie about in these sorts of situations. So, I mean, I always think it's super important to, you know, have video evidence or photo evidence when you move in. If you see damage, you know, it's when you're moving in, the most important thing is if you see damage, record that. And when you move out to, you know, essentially record or like do a video of the whole place or photos of the whole place. But don't like if you move in a week in, you notice damage, you know, that you didn't see maybe when you first moved in. Don't just be like ignore it. Take a picture of it, file it, and make sure you keep track of all the damage that was there when you moved in that you didn't cause.
Yeah, very good. Pictures and video, priceless.
Thank you so much. So that's all the questions that we have prepared beforehand, but if any participants have questions that, or if any attendees have questions that they want to ask, feel free to type it in the chat and we can address them. So I'll just give a few minutes. So Santharia, do you want to type in the learn email?
I also think he's asking for Monica and Brian's contact. If
yeah,
I'm mistaken. I can also type in the learn email though.
Okay. I don't know if you two would like to share contact information.
Yeah, sure.
I'm fine with it. Sure.
Yeah, I'll type my email address into the bar, you know, and so you guys, if you have a question, you can send me an email.
Great, thank you. And then we also have a question that says, any advice you would give to students moving into an apartment for the first time?
I would say definitely, you know, kind of just what we were ending on there, but definitely take photo of any damage, do like a video recording when you move in. Do make sure to read the lease, you know, like a lot of people just skip over it, but it's important, I think, to understand even just like what might seem like a minor provision about parking or about pets or about, you know, like overnight guests or something like that. These things can be really important. So I definitely think it's important to take a look at these and understand what you can and can't do under a lease, especially when you're moving into an apartment for the first time, because a lot of people are coming from houses where they're not used to these sorts of restrictions or rules. And I think it's an important learning experience to read through the lease and understand everything that's going on.
Yeah, you covered it. The only thing I would add is just slow down. Don't get too excited. I've got 4 kids. 3 of them are 2 of them in college. And so I know everybody wants furniture and the 72-inch TV and whatever. Stay within your budget, slow down, take it slowly, and don't overextend yourselves. But you can still have fun, okay?
Thank you. And then we also have a question. What are some accessible resources students can use to research or understand new housing laws or policies?
Google. There's so much online. There's so much information. I'm refreshed when I have clients tell me how much they've read on Google and how much they've learned. It's less that we have to explain as attorneys, but there's as much information as you are willing to absorb. I mean, it's all at your fingertips.
Yeah, and also like I know too, sometimes the courts, especially like they'll have like a small claims section and they'll have like a self-help section where it kind of walks you through the small claims process for like particular actions. Like I believe OC Courts has just a section on requesting your security deposit back from your landlord. And I think personally it does a pretty good job of basically laying out what you have to do in what order, and it gives you the forms and things like that for ultimately if you need to file an action.
Correct.
Okay, great. Thank you. And also someone wrote that you can look at a city's housing element and they post it on their website. So thank you to the person who wrote that. If anyone has any additional questions, feel free to type it in. I also typed in the chat the link to the Learn website, and we have different video series on immigration law, pre-law, as well as a list of various resources for students on practically every legal issue. So you're all feel free to check that out as well. But if they're okay, what should be covered in a written roommate agreement?
I would say, everything that you guys agreed to, of course. Like it's the sky's the limit with that too, because I know Monica, I think, has dealt with this more than I have because most of my clients live by themselves. But it's I think just having the evidence that there was an agreement of some kind is really strong rather than he said, she said. I know Monica said things like chores, I think is super important because I've seen that be a point of contention between roommates more often than I can count. Basically the amount of rent, the portion of the utilities everyone pays, all these things are super important to put out in the rental agreement. But I would say the number one thing is how you're apportioning fees, what everyone's bottom line dollar amount they owe every month. So there's no confusion or room for misconception.
Yeah, I will stress, really stress, you need to have an agreement on what you're going to do when the lease expires. That's got to be probably the biggest problem that I have with clients that are in a roommate situation. The problem starts when one roommate wants to stay and the other one wants to go. And the one that wants to go leaves and erroneously believes that as long as they leave, they're out. That's not true. What I tell people is, to keep it simple, it's all or nothing. You all have to go or no one goes. And that's how your cosigner, your guarantor, gets screwed too, is because they remained a guarantor on your lease, and maybe a roommate skips out, leaves the other roommate behind. Maybe mom of the roommate that moved out is the one who co-signed. I don't know, but that is the worst situation. I just helped a client a couple weeks ago with my demand letter. We didn't have to file a lawsuit, but I sent a demand letter to all the other girlfriends, the tenants, the roommates that were sticking around and they didn't want to leave. And luckily, my client had text messages where all the roommates were in a group text and they had all agreed before the end of last year, they all agreed that they were going to vacate when the lease terminated. So I sent my demand letter. I told them exactly what they had agreed on and that they need to come through and either sign a new lease with the management company that left my client out, or you all vacate. But you're not leaving my client in on this. And they immediately went and got the new lease done. But that's because she had text messages. If she didn't, she would have been screwed. They were planning to screw her. So you've just got to get it in writing. And it can be something simple. It doesn't have to be, complicated. But I put in the chat that I have a roommate agreement that I'll send you guys. I forgot. I was planning to post it to my resources and I forgot. But I have a Microsoft Word doc that's a roommate agreement. I can email you guys. It's not a big deal. And that will have everything in there and you can change it. Okay.
Yeah, thank you so much. That's a really great resource. Okay, so if there aren't any other questions, thank you so much to both of you for being here today. I know we really appreciate it. And thank you so much to everyone who attended. Some of you might be receiving gift cards as well. But yeah, if you have any questions, feel free to contact us and visit the Learn website for more information and legal resources. But yeah, so thank you again and have a good night, everyone.
You're welcome. Thanks for having us. Bye.
Thank you. Appreciate
Thank you for
it.
having us. It was a pleasure.
Nice meeting you,
Bye-bye,
Brian.
everyone.
Take
Thank
care.
you. Bye-bye.
Zot, zot, zot.
Hey.
That's all. Yeah.